There it is. Go ahead, sir.
David I. Goldstein, appearing on behalf of the defendant.
All right. What are we doing on this case?
Going to be setting it for an exam, Your Honor.
All discovery is complete.
Yes, Your Honor.
People have their witnesses available on the 23rd.
Your Honor, I'm going to be out of the country on the, I'm sorry, I stayed on the 23rd. I'm available the 30th or the first week in August, either one.
People have their witnesses available on the 30th?
July.
Yes.
He does the bond violation.
Yes, ma'am.
Yeah.
I do see it.
Which judge is that on the 30th, Your Honor? Do you know?
I'll get to that in a minute.
Okay. Your Honor, I am aware of a bond violation. I did discuss it with the tether agent. When the court's ready.
Okay, go ahead.
Okay. Your Honor, I'm aware that there was a violation, an alleged violation, that he was in the exclusion zone. In that situation, Your Honor, my client contacted me, said he wanted to get some property from the location where he was excluded. I told him he could do a civil standby. Civil standby. He did contact the police. He went to a location, waiting for the police to arrive. And before the police arrived, the tether people apparently violated him.
Well, there's that issue, but then I also have that his tether strap was cut.
It wasn't cut, Your Honor. It was damaged. He had the tether on when the agents arrived, and it was replaced, and he still has it on.
But it was split from the bottom. Why was that?
He was doing something with his pants, Your Honor, and may have accidentally done it, but it was not intentional. In fact, and as I said, he was on when they got there.
I get that, but what could he have been doing with his pants that caused the tether strap to split?
I was trying to cut a hole around it for more comfort on my ankle, and I accidentally
Cut a hole around what?
my pants. Put a hole in my pants so I can get like more comfort.
He was trying to cut around the tether.
Trying to cut around it, but now I just put my pants through it instead of going over it. And I accidentally cut the tether on accident when I was cutting a hole in my pants, trying to cut around it. This part. It wasn't like I was trying to cut it off or nothing. It wasn't that.
You were trying to cut a hole around the tether and
More
you
comfort.
cut the strap.
Well, it didn't, Your Honor, you say cut. There was damage to the strap, but it wasn't cut off.
Okay, if you want to play word games, I'll play word games. I'm looking at the report. It was split from the bottom, so it was cut.
Yes.
It wasn't cut off. I get it. Or it didn't come off of his leg. I'm just trying to figure out how you cut the strap when trying to cut a hole in your pants.
I didn't do these. Now I'm holding my pants over it. It went too deep. I cut all around it. And
You're cutting with a knife?
I used a knife to cut a hole in my pants. I wasn't trying to cut it off though. That was not my intention.
Any response from the people?
Well, I mean, I'm obviously concerned, and then he went past the victim's residence twice. I understand that saying it's because he wanted to get a civil standby, but he should work that out first and contact the tether agency before he did that. I mean, this is a domestic violence case. He had requested a $50,000 bond to begin with. We were denied that at the original arraignment. So there's concerns with the tampering of the tether and also its whereabouts.
Well, is there an indication that the civil standby was called for?
Yes.
I don't have any of the information.
We can get that from the police department, Your Honor.
Probably.
Which one?
Yes.
Who did he call?
But
The sheriff's department?
Sheriff's Department. And it was Ann Arbor though.
Pardon?
It was Ann Arbor. I called Ann
Which
Arbor.
department did you call?
The sheriff's, the non-emergency line.
okay, the Ann Arbor Police and the Sheriff's Department are two different agencies.
It was the police.
The Ann Arbor Police?
Yes.
So you called the Ann Arbor Police Department? got a
Yes,
civil
before I
standby.
left. Before I came out here, I did that.
What?
Yes, before I left out from my house, I did call. I made that call before I left. And they told me to just give them a call when I get to Ann Arbor.
It comes from Flint, Your Honor.
Yes, I don't stay out there.
And did you call them?
Yes.
What date?
Whatever the date of the violation is, Your Honor. It all happened in one day.
So the tether cut was on the 28th at 1:34 a.m. Then the next day on the 29th at 7:30, they received a call that the defendant was in the exclusion zone, the monitoring center. The defendant drove through the exclusion zone, passing the victim's residence twice. Once the defendant became stationary, they contacted Washington County Metro Dispatch and they arrested him.
Now, Your Honor, I realize there's
Hold
an
it. No, hold it. I get that. But if he's got a civil standby and he's telling me he called the county, the moment Metro Dispatch is called, they're going to know that he's there. I need proof that there was a call for a civil standby because my problem right now is I've got what appears to be a tether tamper on the 28th, and then I have him in the zone on the 29th.
with the tether on, Your Honor.
Yes. I have.
Okay, I'm still not understanding this whole knife thing, but he's in the exclusion zone and I don't have proof of a civil standby because that usually will appear very quickly. There would not be a violation filed.
Your Honor,
So I'll tell you what, I'll pass the matter. Somebody needs to you guys need to get over to the sheriff's department, get that information on the civil standby, and I'll call it back up. But if I don't have proof of the civil standby, then we're gonna have a problem.
all right, thank you.
Court calls the case, People versus Noah Williams.
Go back to.
Yeah, his light's on.
Yeah, I know where, you know, this, you know, I'm just, okay, hang on. There we go.
How many people does it take to turn off a light on the phone?
Okay,
3.
thanks, man.
Okay.
David I. Goldstein, appearing on behalf of the defendant. Your Honor, in the interim, my client showed me on his phone log, confirming that on the June 29th at 2:20 p.m., he did make a call to the Ann Arbor Police Department. He called them this morning. They gave him oral confirmation that the call was received. He has now put in a FOIA request. They won't give him a written confirmation without a FOIA request. And he did file the FOIA request this morning. But I can show the court on his phone where in the call log where that call was made.
Okay. You're wanting to set for exam.
Yes, Your Honor.
All right. Here's what I'm gonna do. I will set it for a preliminary exam. With regard to the bond violations, I'll let the court handle any potential bond violations. He's got a new thing on the tether, right?
Yes, Your Honor.
Did you get all of your property or whatever you were looking for that date? So there's no reason whatsoever for you to be back in that area?
No.
Preliminary examination will be set 30th, 2024, 9 a.m. before
Fresh hour.
Judge Freshour.
Thank you, Your Honor.
This time bond will continue. People versus John St. Germain.
Offer for the people.
Not the Overwater Assistant Public Defender on behalf of Mr. St. Germain.
Your name, sir?
John St. Germain.
Thank you.
Your Honor, it's a date and time set for a probable cause conference. We are still trying to get discovery on these matters. The video for one of the two cases was sent to my office yesterday. The other one we still do not have. As a result of this, we still cannot set we cannot set one of the cases for preliminary examination. The other one still has not been set for preliminary examination. In both cases, my client's been in custody for 28 days. So we're past the 21 days for the preliminary examination. My client has directed me to move for a dismissal on the basis of that 21-day violation.
Okay, I'll tell you what. That's fine. Then I'll grant that, but I won't grant it until later. Well, I'll hear the motion later and allow the people to prepare paperwork so that we can just do all of it, swear it out and arraign him on that all today. And then all the time that he's been in, he would lose any credit. So that's what we'll do. That would be my remedy.
That doesn't sound good.
No, it doesn't. But that's what happens. That's how I work.
What can I do?
I've told you we can adjourn to get the video and then set the cases for preliminary examination.
Sure. Okay.
Then thank you, Your Honor. I would withdraw that motion and I would ask that for a brief adjournment of the probable cause conference to get the remaining video.
Do you think you'd be able to have those in a week or did you need two? I appreciate.
Northfield Township Records Department reports that they sent the link yesterday. And so Mr. Runick is working on
Getting that. Got it.
Mr. Overwater feels confident with a week. I'm happy to put it a week if you need 2 weeks.
I'm fine with a week if
All right.
Mr. Ganache thinks we'll have it.
Probable cause conference, July 18th, 2024, 9 a.m. Well, continue.
Thank you, Your Honor.
Your Honor, can I address the court?
Sure.
I'm wondering about getting my bond reduced so that I can post it, because right now it's a little bit high for what I can afford.
Well, okay. Have you talked to your attorney about that?
Yeah, I mentioned it.
We did, Your Honor, and we made a bond motion at the last hearing.
I know.
So the only thing that's changed is the matter continues to be delayed on the issue of discovery while my client is still incarcerated as a result.
Right. And he violated the conditions that we released him on the last time.
I did, and it wasn't on purpose. And I meant no disrespect by it. That's not something that would happen again. As my situation has changed and I have transportation now to my court dates, I have a healthy spot to live in with,
And the court recalls this was explained to the court a few weeks ago, but he does have stable residence with friends, one of whom is a licensed social worker and would look after him as well as ensure his appearance in court.
Had to issue a warrant on one. There was a bond violation. I'm not going to change the bond at this time. I mean, I'll see him next week and we'll see exactly where we are, but I'm not changing. Motion for bond reductions tonight.
Thank you, Your Honor.
thank you.
Case People versus Devin Schiller.
Nimish Ganatra for the people.
Kenneth Overwater, Assistant Public Defender on behalf of Mr. Schiller, who approaches and stands to my right. Mr. Schiller, would you state your name for the record?
Devin Matthew Schiller.
Okay, what are we doing?
Your Honor, I'd be asking to adjourn the probable cause conference. There is a bond violation that I assume the court has seen.
Yes.
So I did speak with my client regarding that. I did indicate to me that he did have a relapse a few weeks ago. He has begun going to, is it Narcotics Anonymous, NA meetings?
They're technically A, but it's kind of like a mixed group.
Right. So he's going to meetings. He's been to, I think, 7 meetings in the last about 10 days. He did provide me with some sign-in sheets to verify some of the later meetings. Additionally, it looks like Community Corrections has referred him to outpatient. He has an intake for that on July 15th, which he will be attending. He continues to test, knowing that those levels are going to reduce, but they will eventually be testing.
Well, I don't have levels. And I mean, I have 3 consecutive tests of fentanyl.
I read on.
When did you start this programming that you kind of created for yourself?
So he started attending the AANA meetings in late June after he had his relapse. He had thought that this was something he could manage kind of on his own. And then he has realized. We're going to have to
find something, Mr. Allen. We're going to have to find something else.
Judge, I'm going to ask the court to consider adjourning this and give him an opportunity to stay on the path that he's on. He has a referral for outpatient, which is not something that he was doing, and that was the recommendation of community corrections. If he's taken into custody today, that's going to derail the treatment plan that he has in place, and it's only going to delay.
It to the extent it's a treatment plan. I mean, what it is it's his notion of what to do. But I've got 3 consecutive testing of.
Your Honor, may I say something?
I don't think that's a good idea.
Okay.
All right, Your Honor, he was at one point a high user. In that instance, it takes time for the levels to reduce. For the levels to reduce. We don't know what the levels actually are, but the report indicates that those can be sent out for testing to determine that the levels are in fact reducing.
If I look at this testing, I don't think he's ever stopped.
I have.
Because the first test, since this case anyway, because the first test, he is an unable or refuse. There's no test. And then 3 consecutive tests, he's testing positive for fentanyl.
And Judge, he reports the last time he used was in late June. Those numbers are reducing. If the court will allow him, there are going to be negative tests coming. He has an intake for outpatient treatment at community corrections.
Fentanyl won't stay in his system that long. That means he's continuing to use.
I promise you, it will be negative next week. When you're a chronic user, I read online that it can stay in your system for up to 4 weeks. I haven't been using in multiple weeks.
Somebody needs to come back with a plan for his release, but he's going in right now. You're not going to have three tests coming back.
The
that.
levels are gone.
You can argue with me if you want. Bonds revoked. Defendant's remanded. I'll set it over to next week, the 18th, 9 a.m.
Thank you, Your Honor.
So I don't have no left. I have no left.
That was a woman that just.
Who was that? Get security down here and find out who the heck that was, because they're not going to walk out of my courtroom that way. Who? Did you see who just came out of the courtroom, Joe?
I did not. I was in the conference room.
Okay.
Black.
It's a woman in a black t-shirt. If she was down in courtroom C, I want her brought back. Court's going to stand in recess.
Robert Ellman with and on behalf of Mr. Hornberger.
Your name, sir?
Thomas Hornberger.
Right.
Your Honor, today's date and time set for PCC. I would at this time like to set this matter for an exam.
I would set it for an exam, except that your client hasn't been tested.
I understand, Your Honor, and I am in receipt of the bond violation report.
Why hasn't he been testing, Mr. Allen?
Your Honor, he missed one test, the first test on the day that we had court due to his misunderstanding of what time court was. And after that, Your Honor, I don't have a good answer.
Well, just so that we're clear on the bond violation, on the June 12th, he did take a test, tested positive for cocaine, fentanyl, and THC. And then the next 3 successive tests, he missed.
And my understanding, Your Honor, is that he thought after missing one test that because that was a violation that he did not need to test further. I've advised him that that was a mistake. He wishes a further opportunity to test on this matter.
You wanted to set for a preliminary examination?
Yes, Your Honor.
Is all discovery complete?
Yes, Your Honor.
People have their witnesses available the 23rd?
Yes, Your Honor.
Preliminary examination in person, July 23rd, 2024. 9 a.m. That's before Judge Washington. You can't just decide you're going to test, not test, do whatever, and particularly have a dirty test and then miss all of the other tests. At this point, defendant's bond is revoked, defendant's remand. Go with my bailiff, sir.
Come see you soon, Mr. Hornberg. Have a good day, Your Honor.
You do the same. Court calls the case, People versus Kanasia Johnson Jackson.
Robert Mullen on behalf of the defendant,
Your name? Yeah.
Kanasia Johnson Jackson.
All right. And this is actually, I think, a time for a PCC and your motion to withdraw.
Yes, sir.
All right. Go ahead with your motion to withdraw.
Your Honor, I put most of the important facts that I think that are necessary. If the court wants details, I'm more than happy. But I believe based on the rules, if I have a financial hardship and continued representation, the court would take that in as a reason for withdrawal. But more importantly, if I can withdraw at a time which will not create any kind of substantial hardship on behalf of the defendant, and I think that would be the case here. We do have all the discovery that we think we're entitled to at this time, but we have not had a preliminary exam. And I don't believe that any of my clients' rights have been prejudiced.
And Ms. Johnson Jackson, anything you want to say regarding Mr. Mullen's motion to withdraw?
Yes, I don't agree with it.
Pardon?
I don't agree with it.
Okay. What don't you agree with?
Based off the that was provided to me in reference to, can I see your paper?
Absolutely.
The one that's under the-
Oh.
It's in there, like, put it down. The email that you sent me this morning.
You want the motion? You want the, didn't you read me something?
Yeah, that's what I'm talking about, the email that
Oh,
was.
hang on.
Thank you.
Mhm.
So this morning, the email that was sent, which is what I'm about to read, it says the defense counsel appear on behalf of the defendant with the understanding that defendant will be remitting forthwith to defendant counsel a retainer payment as agreed upon by defense counsel and defendant. The second one was defendant subsequently failed to remit said retainer payment, nor has defendant indicated when the retainer will be paid. 1 second. The third one is an attorney may withdraw if his client fails substantially to fulfill an obligation to the lawyer regarding the lawyer services and has given reasonable warning that the lawyer will withdraw unless the obligation is fulfilled. So in reference to all that, yeah, in reference to all that stated, the retainer, so him and I, it seems like there is confusion between him and I in reference to the retainer fee and just like the distance of my case. Does that make sense?
No.
So I don't agree. So what he's doing is a motion, right?
It's a motion to withdraw as your counsel.
Right. So I don't agree with the motion to withdraw in reference to this being, this is my probable cause hearing, right?
Well, it is a probable cause hearing, yes.
Right, so, okay, so I have a question. So with him withdrawing as my counsel, are we still doing this today or is that postponed?
If he withdraws, okay, ma'am. So I have to make a determination as to whether or not there are grounds to withdraw as
Understood.
I'm looking at it. So I asked, Mr. Mullen stated his position. I have the motion in front of me, and I'm asking what your position on this motion to withdraw is.
Oh, I absolutely disagree. And to my understanding, it seems like most of like videos and just maybe more statements have been given to my defense, but to my understanding, that is the discovery, but I don't know anything about it because him and I haven't spoke about it. Does that make sense?
Okay, it could, yes.
Okay.
So, ma'am, let me just ask you this. His basis of withdrawing is that you were supposed to, you had certain financial obligations. It's indicating that you haven't fulfilled those. I don't need to know what those specific terms are because it's not relevant to at least the court's determination at this point. Are you indicating to me that you did fulfill those obligations? And therefore, okay, but fully fulfill those obligations?
I haven't fully fulfilled obligations, but I have put money in his hand. So that's why, yes.
Okay.
General, may I respond just, or do you want me to just be quiet?
Go ahead.
Yeah, she's right. She's paid me some money, of course. But the reality of it is it's less than a third of what the retainer understanding was an agreement for this case. In addition to that, I haven't paid anything in almost 3 months. There's been no efforts to pay me. I've had multiple meetings. I had a meeting on the 26th of June specifically to make this a focus. I don't like talking about money. I'd rather work as a lawyer and do the work on the case and have those meetings. But as you know, it becomes a conflict of interest when you're not being paid. This is a capital case. She's entitled to substantial work on this case as it being a capital case. And when I'm not getting paid, I don't know how I'll be able to do it. This is not like an OWI where even if I'm not getting paid, I could probably suffer through it and it wouldn't damage my practice or my mental health. This would be maybe a little more of a different of a situation. But to say that she hasn't paid me any money.
I don't think that she said that.
I just want to make it clear. She has, but she has not even come.
That's not what I got from this. I get it. So, ma'am, are you telling me? I understand that you've paid part of what's there.
Yes.
Okay. But you haven't paid what the entire amount agreed upon was.
You said what the entire amount?
What the entire amount. You haven't paid that.
I haven't paid the entire amount.
Okay. So are you telling me that you're going to?
What I'm saying is there has been some confusion in reference to the amounts. There has been efforts, multiple efforts to make payment, and I have made payment. I have not made the entire amount. But
so let me just ask you this. As to the entire amount that was requested to obtain of the retention, why hasn't the full amount been paid?
Because there was confusion on the full amount.
Your Honor,
I don't know what that means.
Miss Johnson Jackson wrote me out a payment schedule. This was her schedule. It wasn't my proposed schedule. Yeah. She wrote me out a payment schedule and provided it to me and has not even lived up to that. And like I said, less than a third of the retainer in the case. And just so this court knows why I'm a little nervous on top of it is, and I explained this to her, I have a bifurcated billing system. Part of it's a retainer, that's a flat fee. The other part is an hourly when we get into motions in trial. And the fact that we're having such an issue with just the base retainer, I'm nervous. We go further in this case. We get into trial, we're going to have an hourly bill that's going to be accumulating, and I don't have confidence and that bill being paid timely. So hence the motion.
Ma'am, is he right? You laid out an agreement that you're gonna pay?
We did have an agreement,
Ma'am, can I ask you why you just don't answer my question?
because
I think my questions are rather simple. Mr. Mullins has indicated you laid out a payment schedule to him. Is that right?
yes, but it wasn't the total amount being asked. The payment plan that was laid out was not the total amount that is requested. And so when I understand, when I say that there is confusion in reference to it, usually, for instance, people will sign a retainer fee with the lawyer, and that didn't happen. So once again, I did give him money to counsel me. But as far as the total amount, it wasn't.
Then ma'am, explain to me something.
Mhm,
If you haven't done that part,
mhm.
why shouldn't I grant his motion and just let him withdraw?
Because this is the probable cause hearing.
Because what?
This is the probable cause hearing.
Okay, and I give you another probable cause hearing. You won't be in any worse position
Okay.
because that's his obligation. His obligation is not to put you in a worse position when he goes to withdraw. And so that you understand what Mr. Mullins is really saying, and maybe he says just more fancy way than I would. He doesn't want to get to the point where either you're not paying him or something else happens in the case, and then he's either stuck because he can't have you in a safe spot, or he just has to try to get out to save himself, and you're going to be in a worse spot.
I understand.
So can you tell me a reason why I shouldn't let him out?
So I have a question. Can I ask a question?
Sure.
So let's say that you rule that he in his favor. So I would be given a.
Ma'am, let me stop. I'm going to tell you what I'm going to do, okay? And that way we can just put this to an end. I'm going to grant his motion to withdraw. I get it. I think you're a little bit worried that you're going to be left out there on your own. Here's the PCC and whatever. Doesn't work that way here. So I'm going to grant Mr. Mullins' motion. Mr. Mullins is withdrawing from the case and further discharge of any obligation of this client or the court on this matter.
Thank you, Your Honor.
This now becomes a public defender case. You're represented by the public defender at this juncture, okay? That way you still have counsel, very capable counsel to represent you in this matter. Ms. Anderson.
Thank you, Your Honor. First Assistant Public Defender Kalina Anderson with and on behalf of Ms. Johnson Jackson. Your Honor, I asked for a couple weeks adjournment for us to get discovery and speak with her about the case.
All right. All right. Probable cause conference in this matter will be adjourned to July 25th, 2024 at 9 a.m. or as your invite indicates. Okay? Ms. Johnson Jackson, you understand?
Yes.
Okay, so you've got counsel now. They'll get the discovery. They'll be able to go through it with you and pace through it. It doesn't mean if you want to hire another attorney or somebody else, you can still do that. But you've got very, very capable, extraordinary counsel to represent you. So
I understand.
okay. And so bond will continue.
Thank you, Your Honor.
Thank you.